This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes, for number one. Your Lordship,
I am appealing for the response. My Lord, I am appealing for the response number 2. Yes, I am appealing for the response.
Your Lordship's pleasure was to ask me to check up whether the judgment cited by Mr. Bhattacharya was taken up in appeal. I have, not I, my junior has checked up, and I find that the ERJ case that was cited, Delhi bench, that was taken up to the Supreme Court. But the Supreme Court set aside the judgment in view of the fact the order has already been complied with. Therefore, if that is set aside, I may hand up the judgment of the Supreme Court.
So the point of law is still open.
Yes, still open. No, point of law, the judgment is...
From your point of view, point of law is what you say.
Yes.
But through this judgment, point of law is still open.
The Supreme Court decided that nothing remains.
I say...
When a judgment has been set aside, the entire... Sir, let one at a time. Yes, please.
The point of law, I submit, is closed, not open, because so earlier Supreme Court judgments, they hold the field, and here the judgment which Mr. Bhattacharya was relying upon has been set aside. It says
on compliance. On compliance.
On compliance. Because if you want to see is
on compliance.
On compliance.
It doesn't say that the jurisdiction is decided.
But one more question to all of you. What about the special bench of our High Court, which says that even if there is a modification of this thing by the appeal court, then also the first court gets to
modify.
That is in view of Rule 15 of the Contempt of Court rules of this High Court,
which will not be attracted so far as a merger in respect of a judgment with the Supreme Court's judgment.
Because Rule 15 of the Contempt of Court rules of the Calcutta High Court specifically saying...
Because special bench is also binding on us.
Yes. Special bench is also binding on us because special bench has decided it on the view of Rule 15. Therefore, this question which we are now canvassing before your Lordship has nothing to do with
that. Question was also before the special bench.
Modification of the division bench.
My Lord,
no.
If I may...
Clause 2 says modification.
I am a state father. Supreme Court judgments are placed even of 2025, which says even in case of affirmation, this is much. 3 aspects. If it is
affirmed, modified,
or
reversed.
Merger.
In all the cases.
But untouched, if the special petition is not taken on board and not admitted, then another.
Yes. Then Lord.
So the test will be whether or not a review is available to us. If a review is available to us, then we can enforce it.
Yes.
If review is not available to us, then it ceases to exist, and it ceases to exist for all practical
practice.
That is your submission.
Yes. And Lord, one more thing before I...
There cannot be reply to reply. No, don't provoke him, please.
Show that the judgment supports me.
All judgments support him. What can I do?
All judgments support the respective parties. Very good.
But only one more thing, that your Lordship's pleasure was to hear Mr. Bhattacharya on Article 215 of the Constitution
and to 129.
129. Now, kindly have a look at those 2 provisions. I don't know how this is of any relevance in our case, because these really give jurisdictions. If I may just take your Lordship's time for
আরেকটা কনস্টিটিউশনের বই নেই পেয়েছে, ঠিক আছে আমি পেয়েছি, ঠিক আছে আছে আমার কাছে।
kindly see 215 high courts to be courts of record. Every high court shall be a court of record
Same words used in 129.
and shall have all the powers of such a court.
What is your, what do you want to submit?
I see, including the power. It clothes the high court with a power. General power. But when the Supreme, I want to say that under Article 141 of the Supreme Court says it's also law. Therefore, the law laid down by the Supreme Court is also holding the field.
Yes.
Therefore, when the Constitution simply says that High Court will have power as a court of record, Supreme Court will have the power as a court of record, it does not say under what circumstances and who will have jurisdiction. Jurisdiction aspect is not dealt with either by 129 or by 215. I never say that the High Court does not have any power to punish for contempt because it's a court of record. But I say when it merges with the order of the Supreme Court, where
As I see it, if it was an act of contempt on the face of the court, like here
yes,
contempt,
if I just see something,
so then we could have intervened and should have intervened, notwithstanding our judgment getting merged with the Supreme Court.
certainly,
Now, whether on the principle of merger, whether we get denuded of our jurisdiction is something we will consider.
grateful to yours.
Now, my lord, can I make submissions, my lord?
Please, yes.
Yes. Now, my lord, kindly see first judgment, that is the Rampal and another versus D.S. Palla, which Mr. Sengupta has already submitted that the judgment has been set aside. Now, the question has come from, fallen from your lordships. The laws are there. The number one is, when a judgment is set aside, it's entirely set aside.
Yes.
Number two, if the points were required to be left open by the Supreme Court while setting aside of the judgment would have written the points were left open.
Right.
Your normal cases is this: when a SLP is dismissed or any even at the admission stage it is dismissed, the Supreme Court keeps the point open to decide later on. But here, there is no the order which has been placed before the lordships of the Supreme Court. No points were left open.
Very well.
Therefore, there is number three is this. When a judgment is set aside, with great respect, there cannot be any dichotomy of the judgment, the dichotomy of the order, that whether this part has been remained or this part has been remained. It is entirely, it has been set aside. Now, my lord, this is I am submitting, my lord. Next, my lord, the judgment which was cited by this another case, another one, that is, my lord, that the Mariamma Thomas case. Mariamma Thomas, that is 16 SCP online, 41210, 17 December 2016. But, my lord, although no appeal has been preferred against this order, but by a subsequent judgment of that Kerala High Court, in the case, my lord, kindly hand over the judgment, please. Who is there? Kindly hand over the judgment. Amit Matthew.
Yes, yes. Mariam.
Amit Matthew, please. Amit Matthew, my lord. Kindly come to paragraph 9 of that judgment.
আরেকটা ধারের কপি ও এটা দিয়েছো, হ্যাঁ সরি।
One more copy, please.
Yes, yes. Right. One after the other.
applies to contempt proceeding, we are constant to hold that the principles of law has not been correctly laid down in Abin Surah. The point is that your lordship, similar the consideration is this now, whether because of this division bench judgment, although in the first no appeal has been preferred, but it has been overruled already. Although it has not been, my lord, your lordships have considered this question in the Samsung's case, when it is overruled and when it is not overruled. Samsung's case, your lordships have considered, my lord, therefore I do not want to take your lordship. Now, my lord, one of the consideration would be, my lord, which is the paramount consideration, my lord, which is binding. My lord, sorry. Third point is, my lord, I am sorry, my lord, the special bench judgment of this court. My lord, on the first day I submitted, kindly say there is a distinction between a procedure availability or the procedure availability for getting the justices. One is statutory appeal, another is the constitutional provision. Now, my lord, which will prevail? Certainly, my lord, 136, kindly see this, 136 of the Constitution of India, may I just read? That speaks about that special need to act by the Supreme Court, notwithstanding anything in this category. The discretion grants special leave to appeal from any judgment, decree, or order in any cause or matter passed or made by any court or limited. Nothing in this shall apply to any judgment determination or there were 136 provisions, my wife, which I want to submit to lordship, like a 226, like a 32 is a constitutional provision. 136 is also a constitutional provision. It is not a statutory appeal cannot be upgraded like a the constitutional provision. Therefore, justice the judgment of the special bench doesn't stand in the way here. Doesn't stand in the way. Lastly, what which I will submit, the number of judgments have been placed by us, and they have cited 2 judgments. One is another one is Kerala. I have cited another judgment of the division bench of the Kerala, which shows that impact over. Now, therefore, today's question is before your kindly for your lordship's consideration, I will request your lordships to consider whether the Supreme Court judgment which we have cited before your lordships, that binds your lordships under Article 141 of the Constitution, or your lordships will take or have any persuasive value of any other judgment, including the judgment. My lord, kindly, just since your lordships have made an expression, the special bench judgment is binding. Which judgment is binding? Comparatively, whether Supreme Court judgment is binding or the special judgment is binding. Lord, there my submission would be, Lord, the Supreme Court judgment is binding on of your lordships on Article 141. Lord, the judgment of the higher court is binding only because of the judge's interpretation, judge-making law. Nowhere it has been stated, no law is there that is.
Mr. Banerjee, we will be now facing a technical glitch.
What technical glitch?
Your audio might get off.
Sorry, Mary.
Normally it is done. That is when I appear.
No, it's means your lordships are not here. Am I not? I am not audible.
Yes, up to now, yes.
No, need not be worried. I am. I have enough stock.
Yes, very good. Then Mr. Basu, yes, sir.
I will take only 1 minute.
Yes,
Two
sir.
judgment has been cited. Well,
Yes.
if your lordship look to the Gajal brothers judgment, my lord will find that honorable three judges bench says when it is travelled to Delhi and it is granted leave, the order under appeal is erased. If it is erased, my lord, what is to be executed?
Right, we'll consider that. We have to consider it. We'll
And
consider.
the two single judges, the Kerala High Court judgment, other judgment cited with the Protector cannot have any overriding effect of the Supreme Court judgment.
Naturally.
That's all.
Right. Yes, sir. Just one sentence on the news.
Judgment shown.
Yes.
If my permission to read the order without carefully, this is an appeal from the punishment imposed under the contempt jurisdiction.
This issue was not decided.
Not decided. On the contrary, I would say that the jurisdiction is in fact affirmed. The Supreme Court didn't say that it didn't have any jurisdiction to impose punishment. Just without, and then without the
If it did not decide the issue, then either side of the divide it didn't decide.
I humbly submit to logically this issue now has been affirmed by the Supreme Court that the contempt jurisdiction exercised was right. And then say the last line, we have been apprised by Mr. Dayal, learned counsel for the respondent, that the appellant had long been complied with the order. Taking note of the aforesaid, we are of the considered opinion that there is no justification to impose any kind of punishment on the appellants, and accordingly judgment and order passed by the High Court as imposing punishment is set aside. If any proceeding relating to contempt is pending before the High Court, it shall be deemed to have been disposed of. The court doesn't say the High Court didn't have any jurisdiction even to entertain.
There is no occasion. There is no occasion to decide.
My lord, just kindly excuse me, my lord, for 1 second. Kindly excuse me, my lord. I am just seeing the only Mr. Saptangshu Basu's place, not the court.
That is the technical glitch. That is the technical glitch we are talking about.
Malad, kindly see. Kindly, just 1 minute. Kindly, Malad. I have argued. Kindly, this is kindly take note of that. I have argued that in the Supreme Court judgment, points were not left open. If the points were not left open, the question of deciding the question again does not arise in view of that judgment.
Very good. Heard learned senior advocates appearing for the LS contemners. Full stop. Heard learned senior advocate appearing for the petitioner. Full stop. Next paragraph. Hearing concluded. Judgment is served.
Now, Mr. Basu has managed something. Therefore, his place is coming down.
Sir, please, Dada.
His hand is so long. His hand is so long. There he goes.
Same side হয়ে যাচ্ছে
সবাইকে ছেড়ে আমাকে
grateful to again Saptangshu Basu.
Grateful to Dada also.
Also, no.
There were 3 matters.
Yes. অন্য দুটোকে করুন তো, অন্য দুটোকে রেকর্ড করে দিন তো। 8 and 9 separate orders করবেন। Since an issue of maintainability exists in this contempt petition, and since we heard the respective parties on such issue in an earlier in another contempt petition, it would be appropriate to direct the 2 contempt petitions to appear along with the CPN. But to direct the contempt petition to be listed on the date of delivery of judgment of CPN 612 of 2025. 621 of 2025. Same order in item number 9.